Good evening. Thank you for coming to the Salina League of Women Voters Fall Issues Forum. We try to have these every year. This year we happen to have a spring issues forum as well as a fall issues forum, but that's fairly unusual. Of course, we didn't have any issues forums during the pandemic, so we're making up for lost time. Today's subject is what's on your ballot on the November 8th ballot. Most of us know that there are some candidates on our ballot, but many of us aren't aware of the fact that there are a bunch of judges on your ballot, as well as 2 constitutional amendments. These are not the same amendment that was on the primary ballot, 2 new constitutional amendments. And so we tried to bring in people tonight that would give us information about these items that are on everybody's ballot. We are the League of Women Voters, and we are a not-for-profit, nonpartisan civic organization that works to increase public participation in our government, in governing ourselves. I've heard it said that we are supposed to be a self-governing nation, and if we're going to do that, we have to govern. So part of that is voting, a large part of that for many people. And we as an organization, I need to say, have both men and women as members. We have at least one of our men members here tonight. And so we take everybody, and we would love to have new members in the League of Women Voters. We have been an organization since women got the vote in 1920, so that's a long time. Our first presenter tonight is Sue Horst. I got that right? Yes. And she is the State League of Women Voters Voter Service Chair. She is going to talk to us briefly about the 2 constitutional amendments that are on your ballot on the November 8th ballot. Some of you here have items at your table that talk a little bit about these constitutional amendments. So Sue, go ahead, it's your turn.
Thank you. Yes, Susan Horst, and I'm a member of the Johnson County, Kansas League, and the chairperson for voter services for the Kansas State League. And we've got great leagues in the state of Kansas that are all doing so much work to try to get the vote out and educate our voters about issues. One of the issues that I want to talk about is a constitutional amendment that is on one of your flyers right here about the legislative vote to suspend any executive agency resolutions. There's not a lot written about this, but I've listened to a lot of forums about it, and it's very disturbing. The wording that's going to be on everyone's ballot in the state of Kansas seems very straightforward and innocent. It's going to give the legislative officers powers to negate anything that the executive branch might do. And to me, this changes significantly our national and state separation of powers that we live by, so that one branch doesn't overtake another branch of government's authority, and we're all working towards the same goals. And if one branch gets out of order in some way or another, we have other branches to keep them in order. And this change in the Constitution means that anything that happens in the executive branch, whether it's going forward or retroactively, can be negated by a legislative vote. So this amendment says that the legislature can enact a law or a change that says we will authorize a veto of something that the executive office does by, say, 51% vote or whatever they decide is legal for them to take the veto action. For instance, one of the forums I listened to talked about the Health and Environment Committee that has a lot of experts that tell them about the quality of our water and the quality of our air, and if they would pass a law or a restriction saying that you can't put toxic waste in the river. Well, of course, this is a very far-fetched example. I don't know who would ever cancel that advice out, but they could possibly have some business interests that would be affected by canceling toxic waste in the rivers. So they could cancel that ruling, even though it makes sense to all of us. And the executive branch, I was thinking governor. Well, I looked up everything in the executive branch because I'm not a politician. But that includes not only the governor, but Secretary of State that handles all of our elections. If they decide to change something in the election law, the legislature doesn't like voter ID or whatever, they can go back and say, no, we're not going to do that anymore. The Attorney General, I don't know how they can change the law enforcement branch, but they are part of the executive department. State Treasurer, the insurance carrier group. If Health and Human Services, if they decide because of the pandemic you have to wear a mask in public places, well, the legislature can say, we don't care what the experts are saying. We are going to say, we're not going to restrict anybody. You can pass all the germs you want. And it's just that kind of far-fetched thinking, but we don't know really how far this constitutional amendment could reach. It could reach very far. Involved would be the Kansas Department of Education, which sets our curriculum standards. And we have a lot of experts that advise our Department of Education. And all the experts that give our executive offices advice would be just basically thrown out the window, and it's just up for what is a heartfelt issue, yay or nay, instead of facts and scientific evidence. It scares the heck out of me. There's a Department of Agriculture, and in the executive branch there's also agencies that have to do with banking that they oversee, and securities, utilities, interstate commerce, water resources, gaming, and licensing professionals, and all of those areas in executive offices have expert advice from scientists and mathematicians and financial people to make decisions and laws. So it scares me to think that you can just have all of that ignored, even retroactively, and it just basically takes away the power of having executive agencies. And the governor was given power of the governor, which is pretty unspecific in the Constitution, but it's a wide-ranging power in, I think it was 1874, goes way back, hasn't been changed in all these years, and now the legislature wants to change that part of the Constitution. The thing that worries me as much as anything is that anyone I speak to that's not in the league, they'll say, what constitutional amendments? I don't know what's going to be on the ballot. And this is going to be on everybody's ballot in the state of Kansas, so it just concerns me that no one knows it's going to be on the ballot. And the wording is pretty innocent. And then a lot of us get flyers that say, pass this constitutional amendment so that you're not letting people who haven't been elected to office make decisions for you. So it's just very dishonest, I think, to say yes, so you're only being guided by elected officials, because our people, our governors and so forth, are elected, and it's not a simple method to get elected. There's a lot of vetting that goes on. The only thing that I heard on a forum that is encouraging to me is that if this vote passes, which personally I expect is going to pass because no one knows the details. But there was a similar challenge that went to court in 1984 called Stephen versus the Kansas House of Representatives, that the Kansas Supreme Court disallowed a similar change in the law like this due to it encroached on the implied separation of powers in the Constitution. So to me, it just goes back to checks and balances between the branches of government to make sure that everyone has their role and we have a good balance in our government. Does anyone have any comment or any educated information that you want to contribute to that? Because I don't have a lot of other information other than what I've heard in forums and about what makes sense to me. I would just like to see something happen when there's a statewide issue. There's some more publications to the public so that before they get in the ballot box, they have an idea of what these words mean that are on the ballot. Because this issue, it has very deep meaning, but you sure don't get that from what's on the ballot. I didn't. So that's my basic overview, which is not very deep on that issue. The other constitutional amendment has to do with the election and elimination of the sheriffs across the state. And this issue says that every county has to have a sheriff, except of course Riley County, because they have already long in the past consolidated their city and county sheriff, so they don't have a county sheriff right now. And if they decide down the road to have a county sheriff in addition to their city, then this law would apply to them as far as getting rid of a sheriff that is not performing or is doing something against the law. If this vote goes to a yes vote, it gives the power to initiate research for the removal of sheriff to the Kansas Attorney General only. And then the local people involved with the sheriff and the issues would be out of it. If this is voted no, what happens today, and is in the Constitution, is that a local district attorney or the attorney general can initiate legal procedures to research to remove a sheriff. And then on one of the forums I learned that typically if there's a sheriff that it needs to be considered for removal, a district attorney, the local district attorney, may call the neighboring local district attorney and ask him to intervene and help figure out the facts and figure out whether he should be removed or not, so that it doesn't look like the local district attorney is biased, that they're getting an outside view and getting a little more understanding of an outside view of the problem, but not defaulting it to the state. Now, today, a judge then decides whether to remove a sheriff or not, or it could be done by a 40% of the previous voters sign a petition to remove the sheriff, or 51% of the current election voters can hold another runoff to elect a sheriff. So there's methods today, if a sheriff needs to be removed, that can be done. It's just that this law will put it in the hands of the Attorney General for the state, and let's see, it goes to I think there's another Attorney General of State. It just basically takes the power away from the county and back to the state to determine what needs to happen with the local sheriff. And so if if Riley County decides to put in a county sheriff, of course, they would be abiding by these rules. But if another county in the state decided they wanted to consolidate with their city and not have a county sheriff, I think this law would impact them as well, because it would mean eliminating the county sheriff and consolidating with the city. So I think this law would impact them as well. It's very difficult to understand where these things come from, and I'm having a hard time seeing the positives in a yes vote in these constitutional amendments. And whatever you can do to initiate discussions with your neighbors and your friends about these, because anyone I've talked to just has no clue there's constitutional amendments coming up. And so if you're hitting the ballot box and trying to understand these words, it's going to be really hard to understand the background meaning of these. Anyone else have any other information you want to add that would be helpful? Okay, it's not clarifying a lot, but I hope that you get a little better understanding of what you'll meet at the ballot box. Thank you.
Thank you, Sue. I think there's information about this at the, is there some on our local Legal Voters website?
Yes, there is. There are links that will take you places where you can do more research.
There are links on our website, LWVsalina.org, where you can find more information. Would that be under issues, or what would it, what's the category?
It's probably on the homepage or.
Probably on the homepage. There's also a website called Ballotpedia, and you can find out a lot of information about local issues on the Ballotpedia. So those two constitutional amendments, the one which allows the legislature to overrule any rule or regulation that's made by the executive branch, and the other one that says that no county can change its rules on electing its sheriffs. Those are the two that are on your ballot in November. So thank you, Sue, for talking with us and coming here to tell us about that. If any of you think of any questions, we'll have questions later. And so when you're asking the Supreme Court justices questions, you could also ask Sue. Yes, Diana, what do you want to add?
Well, I'll wait until it's.
Oh, you want to, okay. That's good. Okay, so the second part and the larger part of our Fall Issues Forum is presentations by two former Supreme Court justices. We have Carol Beier and Lawton Nuss, and they come to us. They both live in Topeka now. Carol is from Kansas City, Kansas originally. She was telling us that she lived in Seattle when she was a little kid, and then she moved back to Kansas City, Kansas, and she went to college at, what's it called? Benedictine College, and then KU. She's also worked in Washington, D.C. for a while, and then she came back to Kansas and worked in law firms here in Kansas, and then was appointed. Were you directly appointed to the Supreme Court, or did you go through the Court of Appeals?
Yeah, it's been three plus years at the Court of Appeals.
Okay.
If you use your mic, sure.
Yes.
Online.
Yeah, I spent 3+ years at the Court of Appeals first.
Okay, and then was selected as a member of the Supreme Court in Kansas. And our other guest is Lawton Nuss, who is from Salina and was in a law firm here for a long time. And I think even his parents are from Salina, is that right?
I was born in Asbury Hospital.
He was born in Asbury Hospital, and so he knows our part of the country pretty well. He was appointed directly to the Supreme Court from his law office job in Salina and became the Chief Justice of the Kansas Supreme Court. Both Justice Beier and Justice Nuss have now stepped down from the Supreme Court, and so they are free to come here and talk to us about the issues of judges on our ballot. And we don't have any local judges on our ballot this year, but we have Court of Appeals judges and Supreme Court justices. And so I'm going to turn this over to them to present about those issues. Thank you so much for being here.
Thanks very much. Good evening, everyone, and thank you for coming. I was saying before we began that it's always so great to come out and see engaged citizens who are interested in what public servants get up to. And so anyway, it's lovely to look out and see your faces tonight. Lawton and I are going to talk about the courts, as Ann suggested, and specifically about retention elections this year, but I'm just going to start with a story. So here's the story. Before I ever went to law school, I was a journalism student and eventually a journalist. And when I was in college at KU, I had a classmate who, I mean, the best way to describe it, she was just more sophisticated than the rest of us. She came from small town Kansas, but she was very cultured in a high culture sort of way. She played the cello in the university orchestra, and she was just elegant and mature in ways that the rest of us were not quite yet. And then when it came time to graduate, and we were all getting our first jobs, many of us going back to smaller communities in Kansas, her first job was with Dance Magazine in New York City. And as I'm sure you can imagine, for all the rest of us, this was just impossibly cool that she was going to go work for Dance Magazine. Well, she tells a story about having lived in New York for several years and, going to this or that posh function, dinner parties, and eventually the topic of where she was from would come up. And it was fascinating to her dinner companions that she was from Kansas. And eventually, having learned this fact about her, someone would lean over the wisp of nutrition in the middle of their big white plate that passes for a meal in New York City and say to her, "What do people do in Kansas?" And she says, "Well, took me several years to figure out the right answer. Eventually, life brought her back to Kansas, and she actually had a brilliant journalism career in Wichita, raised her family, her life continued." She said, "It really wasn't until a couple years after I'd come home that I realized the correct response." I was always a little flummoxed, but I finally figured it out. The correct response to that question was everything important in life. Everything important in life. So what Lawton and I are here to talk to you tonight about is kind of that subject writ large. Everything important in life, starting and nurturing families, launching and growing businesses, joining and leading civic organizations, trying as hard as we can, even when it's terribly challenging, to have good government. That's what we do. Those are the important things in life, right? And that's what we're here to talk to you about. We want to talk to you about the courts, which are a piece of that good government, an essential piece in how we preserve fair and impartial and non-political courts in Kansas.
As Carol said, let me tell you a little bit about the justices who will be on the ballot on November 8th or on your dance ballots. And they all are native Kansans. They have slightly different backgrounds. And I'm going to explain who they are by seniority. First is our Chief Justice, Marla Lukert. She is a native of Goodland, and she had been a district court judge in Topeka, and she came to the Supreme Court in 2003. Next in seniority is Dan Biles. He's originally from El Dorado. He came to the court after he was a lawyer, and that was in 2009. Next is Caleb Stiegel. He's a native of Lawrence. He came to the Supreme Court from the Court of Appeals, and that was in 2014. Next is Evelyn Wilson. She's a native of Smith Center. She had been a long time district court judge, also in Topeka, and she came to the court in 2020. Next is KJ Wall. He's a native of Scott City, out west, and he had come directly to the court from being a lawyer like I did, and he came in 2020. And the sixth justice is Melissa Standridge. She's a native of Lawrence. She had come to the Supreme Court from the Court of Appeals in 2020. The first three I mentioned, Carol and I worked with for a number of years. They were our colleagues on the court. We know them very well. The other three, while they were not justices with us, we do know them very well through their work either as judges, we reviewed their work, or in KJ Wall's case, he worked directly for me on the Supreme Court, and Carol was very familiar with his work as well. When we proceed with how cases get to the court, do you, up next?
Yeah, that's fine. You go ahead.
Okay. How do cases get to the Kansas Supreme Court? Well, there are three basic ways. First of all, let's say you have a trial here in Salina, and somebody has witnesses, and that person says, I think that the court here in Salina made some mistakes. And so they will file a brief with the Kansas Court of Appeals, and then if the Court of Appeals rules against one of those parties, because you're only entitled to one appeal as a matter of right in Kansas, that can end it. But a lot of people will file what's called a petition for review to the Supreme Court. They'll ask the court to use its discretion and take that appeal or to grant the petition. About 900 of those petitions for review are filed every year, and the Supreme Court grants 65 to 70 of those. Another way for cases to get to the Supreme Court is you bypass the Court of Appeals. There's a case here in Salina, and it can be appealed directly to the Supreme Court. Some cases like that would be death penalty cases, and also eminent domain, where the government has taken your property and you think the compensation you pay was insufficient. The last way for cases to get in the Supreme Court is they start there. You bypass the court here in Salina, and you bypass the Court of Appeals, you can file your lawsuit directly with the Supreme Court in Topeka. An example of that from 2014, there was a man who had won the Democratic primary for U.S. Senate, and named Chad Taylor. And he decided, after he had won that primary, that he did not want to continue. So there's a Kansas statute that's involved, and he went to the Secretary of State's office. At that time, it was a man named Chris Kobach. He submitted his letter and said, I'm withdrawing, take my name off the ballot. And Mr. Kobach wrote back and said, you did not follow the statutory procedures. I'm not taking your name off the ballot. It'll be there in November. So Mr. Taylor's lawyer filed a lawsuit directly with us, and there are limited circumstances under the Kansas Constitution when you can do that. And one of them is when you think a public official is not doing his or her job, you can seek what's called a writ of mandamus, which basically is a court order that you hand to the public official and say, do your job. Well, they had their arguments, and the Supreme Court eventually said, Mr. Kobach, you were wrong. He did comply with the statute. Take his name off the ballot. Here's our court order demanding that you do that. Okay. Before I start talking about the appellate procedure, I'm going to need a volunteer from the studio audience. Do we have any volunteers?
I'm still in that.
You're still in it? You're just going to hand out some materials.
Okay.
After you sing a song for us.
Yeah.
Okay. If you'll just stand by, you're going to be coming back and forth, so you might want to remove your jacket. I'm not sure I did you wrong. Okay. The appellate procedure. As I said, let's say you have a case. in the district court, and somebody loses, and what happens is somebody says, I think the district court made errors, and I want this conviction or this case overturned. In other words, sent back to the district court and told them to do it all again. So what that person does is file a brief, and here I'm going to assume is going directly to the Supreme Court. That person files a brief, and in there, they argue that errors were made and the case should be reversed. And for those of you who were at dinner with us, I'm going to start using that as an example. Because Carol and I are no longer on the Supreme Court, we don't have access to their materials. So I went to the Kansas Historical Society and I pulled out materials for a murder trial in Lincoln County, about 40 minutes northwest of here, in 1888. And I want to tell you, I do want these materials back. Okay. So, the first thing that happens is that person who lost, in this case, is the murder defendant. He was convicted of second-degree murder and sentenced to 20 years in prison. He files a document called a brief, and in there he says, here are the facts of the case that I think are important. Here are the issues, in other words, where the district court got it wrong, and then here is the applicable law, and these are the reasons why I should win. You should reverse my conviction. Mr. Volunteer? Now, like I said, this is a murder case from 1888.
We'll just take a quick scan of this.
Yes, and the defendant's name is Patrick Cleary. Okay. Now, what's important to remember, as you may know, despite what you see in movies and on television, is that when a case is appealed, you don't have the trial witnesses, in this case in Lincoln County, come to Topeka and repeat their testimony in person. Nor do you allow new evidence, new witnesses to be presented. You are stuck with what happened at the trial court level. And so how do we know what those witnesses testified to? Well, in this case, and still today, you have a court reporter who takes down everything that is said. Now, keep in mind that in 1888, the court reporter was a man, happened to be a man, who had a piece of paper and a pencil, and he took shorthand for everything that was said, and then he typed it up. And I'm going to hand out some of the pages from what he typed up. It's the transcript. And it is the transcript that comes to Topeka with that brief. What I'm showing you here, this is the full transcript. There was about an 8-day trial. I'm not going to hand this around, but I'm going to hand you some examples. And keep in mind that he did not have a computer to do this. He used a manual typewriter. Nobody here is old enough to know what a manual typewriter is.
Yeah. Oh, yeah.
Show of hands, okay. And so don't take his transcript apart. He had some strikeouts. He used a pencil in some places to make some corrections, but he was doing the best he could in 1888. Okay. In addition to the entire transcript coming up, other documents that had been at the trial court come to the Supreme Court. This particular case, Mr. Cleary was involved in a gunfight, and he shot the other man in the forehead and killed him. They had a fight over water rights for their cattle. So one of the exhibits at trial was somebody drew a diagram of the location of the gunfight. So the Supreme Court will get a chance to look at that as well and see the different distances. In addition to that, as I said, other items that were used at the trial court will come to the Supreme Court. In this case, this is a motion for new trial. It's handwritten in this case, and it's saying these are the errors that the trial court made, and as a result, I should get a new trial. Now, what we've heard from so far is, this is Mr. Cleary, the murder defendant, saying these are all the mistakes that were made. Well, the state, the prosecutor, gets a chance to file a response brief. And this is what it looks like. This is the county attorney, Mr. Code, who prosecuted and secured the murder conviction. And what he says basically is there were no errors that were made, or if there were errors, they're not serious errors. There's no reason to reverse this conviction. And then, I did not bring one with me, but then Mr. Cleary gets a chance to file yet another brief and say, I'm now replying to what the county attorney is saying in his brief. Okay. Now, I'm just using this as an example, so let's fast forward to 2022. All this material is filed in Topeka. Today it's done electronically, and the justices and their law clerks go through all this information. They'll read through the transcript to make sure that what the attorneys put in their brief is in fact what happened. They'll read the briefs, they'll see the questions of law, the issues that are presented, and then they'll go into the courtroom and they will hear the lawyers argue their cases. In this case, Mr. Cleary's lawyer did 15 minutes to argue his case. And then there are other 15 minutes used by the county attorney, and sometimes Mr. Cleary's lawyer will have a little bit of time to reply, 2 or 3 minutes. They don't do like I am doing and just talk to the justices, because people like Justice Beier will interrupt them and say, now counsel, I've got a question. A minute ago you said this, and now you're saying that. Which is it? Or counsel, I've read the case you're relying on, and I don't think that's quite what it says. Or I have a different interpretation. Or counsel, are you aware of this other case that you don't have in your brief, and it seems to be standing for the opposite conclusion here? Let's discuss that. And all of this is designed for us to get to the right answer. It's not to pick on the lawyers, just like some of them may think. So that case has now been argued. We hear 3 or 4 more cases argued right after the other that morning. Then when we are done with those cases, we go to our conference room. It's just the 7 justices, and we discuss the case. And we go through the issues, we go through the facts, we go through the law. And what's important to remember, and you probably already know, is that I may really have a gut feeling on how I want a case to come out, but doggone it, the law leads me to an opposite conclusion. Well, what the justices do is say, if that's what the law says, that's the conclusion that it demands, then that's what our decision is. So it's not our personal desires or our opinions, it's what the law requires. And you all know that's called the rule of law. Otherwise, why send people to law school to be justices? We could just grab 7 people here tonight and say, here are the basic facts, what do you think? Let's take a look. So, sometimes, oftentimes, it's unanimous. 7 people say the same thing, this is how the case should come out, this is what the law means. And I'll pick on my friend Justice Beier again. She may say, well, you know, Chief, I see things a little differently. I don't think that's the result that the law demands. It should be the opposite of that. So I will write a decision for my colleagues who feel the way I do, and she'll write a separate decision called the dissent. And then the decision I'm writing and the decision she writes circulate among our colleagues. And sometimes a colleague might read her separate dissent and say, golly, Justice Beier, you've got an excellent point there. I now agree with you. But finally, things get resolved. There may be a majority and a dissent. Everybody's looked at it, had their input, and then it is released to the public. Today, it's done electronically. In the old days, it would be released and then bound like this. This is a case from 1876, actually a lot of cases, and I brought it along tonight because I thought you might have an interest in it. It's a case called Wright versus Noel. Mary Wright was a woman who ran for the position of county superintendent of schools in the county south of Topeka. And by God, she won the election. Well, Mr. Noel came in second, and his argument was, This woman doesn't have the right to vote in Kansas, so how can she be voted into an office? And the Supreme Court said, sir, you are wrong. We've looked at the Constitution. There's nothing to support your argument, and she will become the superintendent of schools for the county.
Well, that's amazing.
Oh, you can pass that around if you want, but there's really no need. So people can look at it. Okay. Now, and if you don't want to go to your local county law library and dig through musty old leather-bound books, you can go online, pscourts.org, and you'll find our most recent decisions there. They're found electronically. Now, what's important for you to see, if you want to go through the book, and Justice Beier and I are in real agreement on this point, you will see the facts of the case that we believe are important. We'll list what the issues are that the parties argue. We'll then cite the law that we are applying, and then you will see our step-by-step analysis of how we got to our result. It's called showing your work, if you remember from grade school day. That is unlike the other branches of government who don't have to show all their work. They can, but they're not required to. And sometimes they can make their decisions just by saying, here's the law that we want passed, so be it. Or the governor issues an executive order and doesn't have to explain anything. You can just say, here's the order. There you go. Mr. Beier.
Thanks. So I have a couple points I want to make. The first one's kind of a further educational point, and then a point of emphasis. So, first of all, the one thing I want to make sure all of you understand is we talked about how cases get to the court. I want to talk for just a moment about how justices and judges arrive on the bench. How do they get there? And in Kansas, we have a system that is varied depending on the level of court and depending on geography. For the Kansas Supreme Court, we have what's called a merit selection process. It started originally, I apologize, as a Missouri plan and then spread to other states. And it involves a 9-member commission. 5 of the members of the 9-member commission are lawyers. 4 of them are people who are not lawyers. 4 of the lawyer members and the 4 lay members are divided by congressional district. And each year, a congressional district will have either a lawyer elected by the other lawyers in that congressional district, I should say either, and a lay person appointed by the governor. So any city governor takes 4 years to appoint all 4 lay commissioners to the nominating commission. And then every 4 years, you have the potential for turnover of the entire attorney group of 4. And then the 5th attorney is elected statewide by lawyers. So you have the Supreme Court Nominating Commission. They're responsible for reviewing anyone who wants to submit an application to be on the Kansas Supreme Court. You say, how many notices go out to lawyers? Any lawyer can apply. 11,000. Every time there's a vacancy on the Kansas Supreme Court, lawyers who are eligible by age and level of experience, which is pretty, that's not a very high bar for lawyers, can apply to be on the court, and their nomination papers, self-nomination papers, applications go to this nominating commission. This is not your conventional job application. Justice Standards told me that when she submitted her name for the Kansas Supreme Court, her application materials were in excess of 100 pages. So it's a pretty comprehensive job application. It's reviewed very thoroughly by the commission members. They interview candidates in open meetings, and then they decide in open meetings who should be nominated for the position. And they send 3 names to the governor, and the governor selects the person who will be on the court. That's the merit selection plan that's in place for the Kansas Supreme Court. And each one of these people, 6 of the 7 Kansas Supreme Court justices who you will see on your ballot, arrived at the court by that method. So the Kansas Supreme Court is a constitutional body. It's outlined in the Kansas Constitution. Its selection method is constitutionally provided. Can't change unless there's a constitutional amendment. There's a theme here. The Kansas Court of Appeals, in contrast, is created by statute. So typical, first, second grade, how a bill becomes law. The legislature passes a statute, the governor signs it. So the Kansas Court of Appeals is a creature of statute. This means that although when I joined the Court of Appeals, it had the same Supreme Court nominating commission and merit selection process as the Kansas Supreme Court, a few years ago, the legislature decided it didn't want to use that process for the Kansas Court of Appeals anymore. So the Kansas Court of Appeals is a unique animal in Kansas because it uses essentially a federal model for how judges get to the bench. In other words, the executive, in the case of Kansas, the governor, can select any person, any lawyer that he or she desires, and then that person must be approved, that nomination must be approved by the Kansas Senate. We actually refer to it as the federal model light, because in the federal system, once you have a federal appointment, you have an appointment for life. But in Kansas, you must sit for retention. So both the Kansas Supreme Court and the Kansas Court of Appeals have retention races. For the Kansas Court of Appeals, the judges must sit in the first general election after they've arrived at the court. Same thing with the Kansas Supreme Court, they have to sit the first general election after they arrive at the court. For the Kansas Court of Appeals, then, thereafter, it's every 4 years retention election. For the Kansas Supreme Court, every 6 years retention election. The reason we have this 6 of 7 of the Kansas Supreme Court and half of the Court of Appeals this year, which is a larger than ordinary, kind of a historical anomaly. The reason we have so many on the Kansas Supreme Court this year is that there are 3, as Lawton mentioned a few minutes ago, 3 who served with us for a number of years and who were on the ballot in 2016, whose 6-year terms will be expiring, and then 3 who have replaced 3 of the justices who have retired since that time. Chief Justice Nuss, our colleague Lee Johnson, and myself. So we have 6 of the 7 Supreme Court justices on the ballot this year. Finally, just on selection methods, so you're aware, we have 31 judicial districts in Kansas. About half of them use some form of merit selection, but it's local or regional, depending on whether it's a single county district or a multiple county district. So they have a local nominating commission or regional nominating commission, and then the governor appoints, no Senate confirmation necessary. Or the other half of the districts, and this is a district option, periodically it comes up that the district may want to change its mind about how to get its judges on the bench. The other method for district court or trial court judges is regular partisan election, just like you see in all the other elections where you have candidates who declare a party, they campaign like partisans, and they're elected like partisans. So that's the selection method in Kansas. That's what you want to be aware of. Retention elections are not partisan elections. They're just yes or no. And in order for a Kansas Supreme Court justice or a Kansas Court of Appeals judge to be retained, that person must receive 50% plus 1 yes vote on the election day. So 50% plus 1 vote, yes is the vote if you want to retain the justices or judges, no is the vote if you want to have them swept out of office and have them replaced. And if in fact a justice or a judge is defeated for retention, then that process I've described would begin. That process of submission of applications, Supreme Court nominating commission review, and then replacement by the sitting governor. If it's Kansas Supreme Court, if it's the Kansas Court of Appeals, then you would have that other process, that federal model light would kick in. One of the other jobs besides job 1 that my colleague described of actually deciding cases, I always refer to that as job 1. The other thing that the Kansas Supreme Court does is it runs your judiciary. It runs the state judiciary. It is in essence the board of directors for the state judiciary. More than 1,600 non-judicial employees, in excess of 250 judges statewide. It's a pretty big organization with a lot of moving parts. And the associate justices of the Kansas Supreme Court are essentially members of the board of directors. The chief justice is essentially the chair of that board of directors. There are administrative personnel who assist in the execution of policy, but that board of directors sets the policy, sets the direction of the courts, helps to run all of the various, many programs, committees, and commissions that the court is responsible for. So you can imagine that if a number of Supreme Court justices leave the court simultaneously as a result of retention election defeat, that system would be disrupted. So you need to be aware of that, be able to discuss this in an informed way with your family members and friends and neighbors and all of the folks who will be voting on this November. That's my point of education. Here's my point of emphasis. You heard the chief describe the appellate process, how parties come to the court, how their cases get decided, how the justices and judges must show their work when they're at the appellate level. So I want to emphasize, what do the justices and the judges consider when a case comes before them? 3 things, and only 3 things. The issues raised by the parties and their counsel. The justices don't just sit around and say, well, we like that over there, but we don't like that over there. So we're going to intervene in this public issue and rule. The parties must bring issues to the court. So the issues framed by the parties and their counsel, that's number 1. Number 2, the facts of the case. But not just any old facts. They don't get to go Google it. They have to look only at the facts as demonstrated to exist by admissible evidence. So what I'm describing is a universe, right? A limited universe of information. The issues, the facts as I describe them, and finally, the governing law. Now this isn't some template, it isn't some stamp that applies in every case. Certainly there can be loud, lively disagreement on these points, on these 3 things. But they are the 3 things if judges are performing their duties correctly. So it's important that you know this about these folks that we've mentioned tonight. My colleague described that we know them well, we've observed their work, and we appreciate and can convey to you enthusiastically that these justices, these judges in the Court of Appeals understand the role of the judiciary, their role as appellate jurists. This differs completely appropriately from the way decisions are made in the 2 political branches. When an executive or a member of our legislative body needs to make a decision, they, of course, consider public opinion, voter preference, constituent desire. Of course they do. They appropriately consider their own personal views, their personal morals and ethics. And they consider, and we expect them to consider, in fact have a right to demand they consider, their party platform, their party position. These are the things that go into sound decision-making in the political branches. They have exactly 0 to do with judicial decision-making. And it's important that all of us understand this, that all of us understand it, and that we know that our votes on election day in retention races should appreciate this as part of what helps us make our decisions.
As a follow-up to what my friend Justice Beier just said, let me read a quote to you. And I know there is lots of news about, oh, that person's a liberal justice, or that person's a conservative justice, or that person's a moderate. So they must have different ways of doing things to get to the results that they want. Well, let me read a quote from a former justice on the United States Supreme Court who was a known conservative, Antonin Scalia. And this is what he told a law school class about 15 years ago. If you're going to be a good and faithful judge, you have to resign yourself to the fact that you're not always going to like the conclusions you reach. If you like them all the time, you're probably doing something wrong. And that's just his pithy way of saying what Justice Beier was saying. We may not like the result, but that's what the law requires. All right, so how do judges get there? Well, first of all, since 1868, every judge in the state of Kansas and every state officer in the state has been required to take an oath. And I will pass this around with my studio volunteer in about 30 seconds. But basically, you solemnly swear to support the Constitution of the United States and the state of Kansas, and to faithfully discharge the duties of your office. That's been with us since 7 years after Kansas became a state. 1868. In 1974, the voters of Kansas went to the polls in a statewide vote, and they said, we not only want this requirement in our statute, which the legislature can change at any time, we want it in our state constitution, so that only the voters are the ones who can take it out of the Constitution. And they passed that, it's now in the Constitution. Now, you've heard people talk about the Constitution. Among lawyers and judges and justices, it's known as the people's document, for the reason I just gave you. Because the people of Kansas go in a statewide vote to make changes to it. Just as they did in 1859, when the voters said, this is the Constitution that we want. And every amendment since then, the voters in a statewide election go to the polls and make that decision. So, what's important to know is that if you as a judge are taking the oath to support the Constitution, that means you are sworn to protect the Constitution. And more importantly here, protect the rights of Kansans that are enshrined in the Constitution. And judges and justices are the only state officers who really deal with the Constitution and the constitutional rights on a regular basis. They're the ones who look at the amendments and look at your rights, for example, to a fair trial, to have effective assistance of counsel, to not have a confession forced out of you that's involuntary, to be able to peaceably assemble in public. And the list goes on and on. So judges are unique. Yes, they take the same oath that the Attorney General does, the Governor does, other state officials that you were mentioning earlier, but the judges who deal with them on a regular basis, and they're the ones who are protecting those rights. Yeah. Now, that is one thing that makes the judges and justices unique. The other thing is something called the Code of Judicial Conduct. These are requirements that mandate how the judge has to act. And I'm going to read a couple things, but they all go to the issue of the requirement that the judge be impartial, to be fair, not to dream up issues ourselves or to go outside the record from that murder trial and come up with something else. Or say, well, you know, the law would require me to reach this result, but I don't like that result. So I'm going to rule the other way. That's not being impartial. This is canon 2 of that code. A judge shall perform the duties of judicial office impartially. And then the rule that goes along with that canon says something very similar. A judge shall uphold and apply the law and shall perform all duties of the judicial office fairly and impartially. And the comment to that rule says, this applies even if the judge doesn't like the law you've sworn to uphold. And the code goes further to say, this is mandatory. Shall means must. And oh, by the way, if you don't follow the code of judicial conduct, you can be disciplined for any violations. Well, I think Justice Beier has already told you what our message here today is. To retain these justices that we know so well. We've worked personally with a number of the court of appeals judges who are also on the ballot. And we would ask that you vote yes for them and spread that word as well. And it's not like we know nothing about them or know nothing about the law. It's like if you're choosing a doctor, the best thing to do is go to another doctor and say, do you know this person? Who would you send your family to? That's what we're attempting to do here. Now, one other thing I wanted to show you, and then I will let Justice Beier and Ann do their musical duet, or we'll conclude for questions and answers. But it's a little bit more of show and tell. We talked about the Constitution. The Constitution of the state of Kansas and the United States are contained in this book. You're free to leaf through that. I've highlighted a number of the sections just for my own reference. Feel free to look through. This whole idea of why judges and justices are concerned about constitutional rights and reviewing what lower courts have done and reviewing what the legislature does and what the governor does. And in the case I told you earlier about Chris Kobach, reviewing what the Secretary of State does, that is not something that the Kansas Supreme Court just dreamed up when I became chief 13 years ago. This is essay number 78 in Federalist Papers, written by Alexander Hamilton in the 1780s. And he's the one who started talking about what's called judicial review. And then the U.S. Supreme Court followed suit in 1803, about 20 years later, in a case called Marbury versus Madison. And then the Kansas Supreme Court in 1903 put it all together in this book called Woodmansey. So they talk about Hamilton in the Federalist Papers, they talk about Marbury versus Madison, they talk about the oaths that the judges take to follow the law. It's just nicely summarized here. And it's bound the same way as the Wright versus Knoll, so it's nothing special about the binding. But if you want to look through that, you can see they set forth the facts and issues and their analysis on how they got to their result. So I think that is about all I had, Justice Beier. She says it's time for me to be quiet. Anybody have any questions or comments?
And I have a question on the amendment. The sheriff's amendment troubles me because in my review of trying to study Kansas history, there's over 80 counties that population peaked way back over 100 years ago, 110 years ago. Those counties are now, some of them are like 2,200, 2,500 population. and still going down. So at some point, it seems like the state's gonna have to again look at county consolidation or consolidation of county services. So one of the things I can see that we could do is to do something like Junctions or Manhattan, Riley County did, and 2 or 3 counties could go together and have one sheriff. Now, whether they elected him or one police department, one way or the other, it would probably take an act of the legislature to approve them doing that. But if this amendment passes, then they can't consolidate. Is that correct? That they could not consolidate, say, sheriff services through some kind of an agreement and the legislature. Is that right?
Well, the last section of this proposed laws says a county sheriff only may be involuntarily removed in office by a recall election pursuant to section 3.
That's not what I'm talking about.
Oh, the recall, okay.
I'm
Yeah.
talking about the fact that
The
a
reorganization.
county
of
isn't big enough to support a sheriff. It takes like 10,000 people and their taxes to support a sheriff and a police department.
I think they have to go through this new procedure.
Yeah,
to-
but
you know.
I think that if this were passed, you couldn't have a new procedure without getting a new amendment to the Constitution. Yeah.
Exactly.
I'm not an expert on the amendment, but it seems to me that there are at least a couple of facets to it. The first one is what Susan talked about primarily, which is kind of the tension between local control or state control on this law enforcement officer. You know, who picks them, him or her, who chooses them and who can get rid of them. So that kind of local control issue. But also you have, there's just this is general about constitutional amendments. The Constitution, federal, state, I mean, it's primary. When we decide these cases, you know, we may refer to constitutional law, we may refer to statutory law, we may refer to common law, meaning prior decisions of the court. The Constitution is supreme. And whether we're talking about the federal Constitution or the state Constitution, it's meant to be an enduring document. An enduring document. Not something we change willy-nilly whenever we get the feeling we might want to. And one of the concerns I have, without being an expert at all in this amendment, is does it put us in a place that we may not want to stay in forever? Because it's difficult. It's intentionally difficult to amend the Constitution. So once you amend it and it has a new provision or a new voice or a new requirement, does it reify, does it freeze something that we may or may not fancy a few years down the road? So I think, you know, it's a good question. I don't know the answer to it, and I don't know whether Susan does, but it's a question worth asking every time somebody wants to amend the Constitution.
Yeah, the question of how we're going to consolidate, keep these small counties going could be adversely affected by this constitutional amendment.
It's not easy water.
I'm just going to add to that, it's not a constitutional issue, but it's a statutory issue, but there are some similarities, and here is that issue. There's a statute that says every county in Kansas is entitled to one judge, at least. And you've got larger cities and counties with 500,000 and 600,000 people saying, we're short judges here, but you've got a judge out here in this county with 1,500 people or 2,000 people, and those judges just don't have enough to do to keep them busy. And that goes somewhat to your issue of you want some efficiencies here, but then you also, in that case, I'm talking about people now in smaller counties, we need to have a judge, we need to have a courthouse. So there's tension as you were talking about.
When you have a state that has such a widely varying population, you have a lot of tension about having the local judge versus being able to support the infrastructure for that judge. Yeah, Ann?
It's kind of a two-part question. Have any of the Kansas Supreme Court justices, you may not know this, but do you know if any have either been not retained or have they been disciplined in recent history?
In terms of not retained, I don't believe any of the Kansas Supreme Court justices has not been retained in recent history or ever history. Discipline, we might or might not know about, because some forms of discipline, of course, are not public, some are public. But no, as far as I know in recent history, no, they have not been disciplined. On the non-retained question, I just want to address that a little bit more fully, not to belabor it. When I came to the Court of Appeals in 2000, I was appointed by Governor Gray's to Court of Appeals and then later by Governor Sabin's to the Supreme Court. When I arrived in 2000, retention races were sleepy affairs. You would be up, I don't think anybody even stayed up late on election night because you would get 70, 80% yes vote. That was kind of the natural landing place. In the recent past, and this is not a secret, I'm not telling you something they have not said themselves and that hasn't been published in the press. There are people who want your state court system, and particularly the appellate courts, to be tools for the achievement of specific policy outcomes. That's what they want. They're not making any secret of it. So really, I don't think we overstate when we say that this year and some of the more recent retention years are so critical on that decision point. What do you want? How do you want your Kansas appellate courts to function? Do you want them to continue to function as we have described, where the universe of information that can be considered in deciding cases is this universe that has been established by deliberate design of the founders and long tradition and expectations created by that oath and by that judicial code of conduct? Or do you want to go ahead and just make your courts another vehicle for achievement of political ends? It's a big change. And in the recent past, and those 70, 80 halcyon percentages of yesteryear, that doesn't happen. Now we're seeing retention votes that are in the low 50s sometimes, in the mid 50s. That's getting really close to 50% plus one. And this year in particular, we've had a noisy, sometimes nasty year. And even though the court itself and its membership was not on the ballot during primary season, it was often prominently featured in harsh, vicious attacks. That's because people want to achieve policy outcomes. They want to achieve policy outcomes, which really just, what we're asking you is when you go in the ballot, when you go and you fill out your ballot, when you go in that voting booth, just remember what courts are for. What courts are supposed to be
The Federalist book that was being circulated, you know where it is right now, as the paper, well, here it is. Two things I'm going to share. I talked about Alexander Hamilton writing essay number 78. By the way, all these essays were written to try to persuade the 13 colonies in America to ratify this Constitution that the founders put together in Philadelphia. And his Federalist essay number 78 is titled "The Judges as Guardians of the Constitution." And that's kind of what we've been talking about tonight. And he goes on to say that, well, I can't find it here, but he basically says, if the courts are under the sway of political pressure by a particular party, be careful, because that political party could tomorrow not be in power, and another political party is, and then the judges have to do what that party wants done. And there's nobody to guard the Constitution and protect your individual rights.
Are there any other questions?
Thank you so much for coming. Let's give him a hand. Very, very